Real estate contracts. Key term review. Assignment refers to the transfer of rights and duties under a contract. Attorney in fact is a person who is authorized to perform certain acts for another under a power of attorney. Bilateral contract obligates both parties to perform in accordance with the terms of the contract. Buyer brokerage agreement is an employment contract with a buyer. Community Development District is an independent special district created by law to service the long-term needs of its community. Competent. Parties have the legal capacity to contract, no mental defects, and are of legal age to contract. A contract is an agreement between two or more parties to do a legal act for a consideration which enforces certain rights and obligations. Enforceable contract is a legally binding contract that the law will recognize. Exclusive agency listing is given to one broker, but the seller reserves the right to sell the property without paying a commission. Exclusive right of sale listing is a listing given to one broker who is assured of a commission no matter who sells. This is best from the broker standpoint. Fraud is the intent to misrepresent a material fact or to deceive in order to gain an unfair advantage or to harm another person. Good consideration is a promise that cannot be measured in terms of money, such as love and affection. Homeowners associations are responsible for the operation of a community in which the voting membership is made up of parcel owners. Membership is a mandatory condition of parcel ownership, and the association is authorized to impose assessments that, if unpaid, may become a lien on the parcel. Liquidated damages is the amount specified in the contract, usually the earnest money deposit, to be paid to the seller in case of default by the buyer. Meeting of the minds is reaching an agreement on all terms in a contract. Misrepresentation is an untrue statement of fact or the concealment of a material fact. Net listing is created when a seller agrees to sell a property for a stated acceptable minimum amount. Novation is the substitution of a new party for the original one. Open listing is a listing given to any number of brokers, This is least preferred by brokers. An option contract is a unilateral contract only the optioner must perform to keep open for a specified period of time an offer to sell or lease real property. A peril contract is an oral contract. Procuring cause is the chain of events that results in a sale. Statute of frauds requires that certain contracts must be in writing and signed to be enforceable. Contracts conveying an interest in real property. Statute of limitations designates the period of time during which the terms of a contract may be enforced. Unenforceable means a contract would not stand up in a court of law because it does not meet the requirements of the statute of frauds or it runs beyond the statute of limitations. A unilateral contract obligates only one party to perform. A valid contract is binding on both parties and legally enforceable. Valuable consideration is the money or a promise of something that can be measured in terms of money. Vendee is the buyer. Vendor is the seller. Void contract does not mean all of the required elements of a valid contract and has no legal effect. Avoidable contract allows one party to avoid contractual duties, such as when one party is a minor or a party is mentally incompetent. Key concepts. Contracts in general. An agreement between two or more parties to do or not to do certain things supported by a sufficient consideration. Key to every contract are the promises made. 4 types of contracts real estate licensees may prepare. A listing agreement is the broker's employment contract with the seller. The buyer brokerage agreement is an employment contract with the buyer. Sale and purchase contract may be prepared by the sales associate if the licensee acts as an agent or facilitator for contracting party. An option contract is an agreement to keep open for a specified period an offer to sell or lease real property. Licensees may not draw deeds, mortgages, promissory notes, and leases. Licensees may fill in the blanks on Florida Supreme Court pre-approved lease instruments for lease periods that do not exceed 1 year. A valid contract complies with the provisions of contract law and has 4 essentials. Contractual capacity of the parties, meaning everyone is competent. Offer and acceptance, mutual assent, meeting of the minds. Legality of object, legal purpose, and consideration. 2 types of consideration: valuable, meaning money, or good, the promises each party agrees to. Statute of frauds requires that contracts conveying an interest in real property and contracts that are not to be performed within 1 year of the date created must be in writing and signed to be enforceable, which are purchase and sales contracts, option contracts, deeds and mortgage instruments, lease agreements for a term longer than 1 year, listing agreements for a term longer than 1 year. Statute of limitations for written contracts is 5 years, and for oral or peril contracts is 4 years. Contracts may be written or oral. Contracts that involve a transfer of real property must be in writing to be legally enforceable. The parties to an oral real estate contract may have a valid contract, contains the 4 essentials, but the contract will not be enforceable in a court of law. Letters and telegraphic communication can be part of a valid sale contract. Elements of a valid and enforceable real estate sale contract. Remember COLIC. Competent parties, offer and acceptance, meeting of the minds, legal purpose, in writing and signed, statute of frauds, and consideration, valuable or good, COLIC. Void, voidable, and unenforceable contracts. Void contracts lack one or more required elements of a valid contract and have no legal effect. Voidable contracts allow that one party is permitted to avoid any contractual duties. Unenforceable contracts appear to have all essential elements but cannot be enforced in court. Real estate contracts are not required to be witnessed or notarized, nor do they require a deposit. Formal and informal contracts. Formal contract is written and under seal. Informal, peril, contract is oral. Bilateral and unilateral contracts. Bilateral obligates both parties. Example, sale contract. Unilateral obligates only one party. Option contracts. Express or implied contracts. Express contract exists when all of the terms and conditions have been spelled out and a meeting of the minds is reached. Implied contract exists when some of the conditions may be reasonably implied. Executory and executed contracts. Executory contracts are not fully performed. Executed contracts have been completely performed. Contract negotiation. Offeror, person making offer, and offeree, person receiving offer. Note, parties switch roles when there is a counteroffer. A contract is created when 3 events occur. Offer is made by the offeror, offer is accepted by the offeree, and acceptance is communicated back to the offeror. If the statute of frauds is applicable, the acceptance must be communicated in writing. Ways to terminate an offer. Wild card. Withdrawal by offeror, insanity, lapse of time, death, counteroffer, acceptance, rejection, and destruction of the property. Wild card. Ways to terminate a contract. Performance, mutual rescission, impossibility of performance, lapse of time, bankruptcy, and breach. Remedies for breach of contract. Specific performance. The court orders the other party to perform according to the terms of the contract. Liquidated damages. Amount of damages stipulated in the contract, usually the earnest money deposit. Rescission. Cancellation of the contract and restoration of the parties to their original positions. Compensatory damages. Involves a lawsuit to recover the actual amount of the monetary loss. Unliquidated damages. Assignment and novation. Assignment does not terminate a contract. Transfer of a person's rights and duties under a contract to another person. Contracts are assignable unless prohibited in contract. Novation is used to substitute new party for original party. Types of listings. Open listing, exclusive agency listing, exclusive right of sale listing, net listing, multiple listing. Multiple listing refers to a service provided by brokers and not to a specific type of listing. Broker's compensation is specified in the listing or the buyer brokerage agreement. Find a purchaser, effect a sale, procuring clause. Option contracts. Optioner is the property owner. Optionee is the prospective buyer. Optioner has obligation to sell. Optionee has a right to buy. Unilateral contract. Contract disclosures. Material defects disclosure. Sellers of residential real property must disclose material defects. Radon gas disclosure consists of explaining what radon is. Lead-based paint disclosure applies to sale contracts and leases if the home was built prior to 1978. The energy-efficient brochure informs buyers before signing the sale contract of the option for an energy efficiency rating on the building. Homeowners Association disclosure requires sellers of property subject to a homeowners association to provide buyers with a disclosure summary. Property tax disclosure concerns ad valorem property taxes. Building code violation disclosure applies if a seller has been cited for a building code violation and is the subject of a pending enforcement proceeding. Community Development District disclosures. Timeshare resale listing agreement disclosure and timeshare resale contract disclosure. Misrepresentation and fraud. Misstatement of fact or omission or concealment of a factual matter. 3 elements for fraud. Elements for a cause of action for fraud. The licensee made a misstatement or failed to disclose a material fact. The licensee either knew or should have known that the statement was not accurate or that the undisclosed information should have been disclosed. The party to whom the statement was made relied on the misstatement, or the party to whom the statement was made was damaged as a result. Important dates and time periods to remember. 10 days. Time period sellers must allow home buyers to conduct an inspection for the presence of lead-based paint. 5 days. Time period after title transfer regarding a building code violation to forward to the code enforcement agency the name and address of the new owner and a copy of the disclosures given to the buyer. 4 years is time period to enforce oral contracts under the statute of limitations, and 5 years is the time period to enforce written contracts under the statute of limitations. So 4 years for oral contracts and 5 years for written contracts.